Thank you, Mr. Speaker. I'm standing in this House on behalf of my constituents of Kanasatake who have outwardly expressed their opposition to this. I have consulted much with the band and spoken with Ellen Gabriel, who's a member of the band of Kanasatake. And I can clearly and without regret, reservation, thank you, say that First Nations are not agreeing with this legislation. S-2 makes changes to the Indian Act that allow for provincial family law to apply on reserves in the event of a matrimonial breakdown or the death of a spouse or a partner. Now, while the intention of this act is to give equal property rights to both spouses in the event of a separation, the problem is that this bill cannot be implemented, and the government completely ignored any consultation when preparing the legislation, or they would have known that this bill cannot be implemented. There is a legal vacuum concerning real property on reserve due to the jurisdictional divide between provinces and territories, which have jurisdiction over property and civil rights within provinces, and the federal government, which has a jurisdiction to legislate regarding Indians and lands reserved for Indians, put that in air quotes. The Indian Act does not provide for the division of MRP upon marriage breakdown, and First Nations jurisdiction is not explicitly recognized by Canada in this area. So this is a problem, but Mr. Speaker, anyone who's paying attention to the situations and issues that are facing First Nations in Canada know that it is the Indian Act that is flawed beyond repair. New Democrats, we support the will of the Assembly of First Nations and many other individual nations who have taken the step of explicitly calling on this House to scrap the Indian Act of 1876. We need to begin anew. We need to do this through a broadly consultative process with equal partners. That is key. We need to understand that we are talking about equal partners in this confederation. And that is the only way that we're going to move forward out of this colonial structure that exists. We need to write laws for Indigenous peoples that are not founded on colonialism and racism like the Indian Act is. Yeah. But we need to do it with recognition that First Nations have inherent right to their land and to govern themselves. That would be the way to move forward, through collaboration, consultation, and on good faith. I believe that Canada can take effective steps towards decolonization of Aboriginal peoples in this country. The Indian Act is not the roadmap towards decolonialization. It is a template through which Canada colonized Indigenous peoples in the first place. The legislative gap surrounding matrimonial real property, MRP, is a problem created by the Indian Act, which neglects to account for the division of property in the event of a matrimonial breakdown. It is a function of the Indian Act to place all reserve lands and care for status Indians under the fiduciary responsibility of the Government of Canada. I don't think it's a matter of opinion at this point in history that Canada has not lived up to its responsibility, and they continue to not provide equality for First Nations, as exemplified by the fact that First Nations child welfare and schools continue to be grossly underfunded compared to non-First Nations children by about 30%, according to our own Auditor General. When it comes to matrimonial real property, the obvious problem that arises from the jurisdictional gap created by the Indian Act is that an Aboriginal woman is often not entitled to the lands or home she once shared with her spouse. So it would seem logical, from a very shallow perspective, like this government has, that we should simply write a law that gives women on reserves the benefits of provincial matrimonial laws, thus neatly filling a legislative gap. However, Mr. Speaker, this simply doesn't work in reality for the women living on reserves. Firstly, First Nations people don't own the land they are on. They can't simply sell or divide the way that non-First Nations person can own and sell and divide land. Secondly, even if the Band Council wanted to give a woman her own property on reserve, they would not be able to, as there's not enough land. And this is a problem that we are seeing in Kanesatake, with the government constantly causing problems and delays and changing the rules of the game. When Kanesatake is trying to move forward, they're trying to have land and an area, a band that has jurisdiction over its land for the future generations. The government is not doing that for them, and it's just continuing to cause problems. And so we can't talk about, land without actually addressing the problem that First Nations don't have jurisdiction over it, or they don't have the ability to control what's going on with their land, and they can't access the lands that are traditionally theirs. The trouble with S2, as I was saying, is that practically speaking, it is impossible to implement. So S2 becomes an insincere and overly simplistic attempt to rectify a very complex problem that is caused by the Indian Act. There are obvious gender discrimination problems with MRP on reserves, but the reasons we can't implement it are a lack of financial resources to support First Nation governments to actually implement the law, and a lack of funding for lawyers. This is a problem again in Kanesatake too. It's just causing more and more debt whenever they have to defend their land from a mining company. Lack of funding to account for limited geographic access to provincial courts. So First Nations, Aboriginal peoples living in remote areas can't necessarily access easily a provincial court where they would have to go defend their MRP. Lack of on-reserve housing and landmass, which would be necessary to give both spouses separate homes on reserve. So in a sense, we would be doubling in some areas, for some people, the amount of land needed, and the land just isn't there. The housing is not there. There's difficulty to actually be able to get more resources in order to maintain and build more homes on reserve, let alone the lack of space to put it on. And the government would know all this if they actually troubled to consult. The consultation that's required, and consultation, by the way, doesn't mean, we got a letter from them saying what they wanted and then we ignored it. It means actually having a real discussion and coming to solutions together on equal footing. According to the UN Declaration of Rights of Indigenous People, UNDRIP, consultation requires consent. Canada has conducted limited consultation. No consent was given. So S2 is in violation of UNDRIP, something to which we are signatory, although it was difficult to get us on board because, well, I think Government of Canada in all its previous forms and its current one do not actually want to address meaningfully the problem of colonialism and racism towards First Nations people. UNDRIP requires free, prior informed consent on any matter relating to the lands and welfare of rights holders. And not to mention the fact that we're basically continuing to ignore the Constitution Act that states that First Nations have jurisdiction over their own internal affairs. So, New Democrats, we're not going to support this legislation. It needs to have non-legislative remedies. That we need to have non-legislative remedies to problems that are occurring in the government's relations with First Nations. We need to actually address violence against Aboriginal women. What we've been doing up until now has not actually been addressing. If they were on the ground, if they consulted, they would know this. If they didn't ignore testimony that has been given at Status of Women Committee, they would know this. We need to address the housing crisis, and we need to just end the systematic underfunding that's just perpetuating this discrimination across generations. the government just wants to put a law in the books and say that they've solved the problem, not actually deal with the underlying problem. And they continue to ignore First Nations voices, First Nations women's voices that are calling for us to have a meaningful discussion, stop managing First Nations like colonial subjects, and truly understand that they are partners in this confederation. Thank you, Mr. Speaker.
Questions and comments? The honourable Parliamentary Secretary for the Environment.
Thank you, Mr. Speaker. And I do share my colleagues' concerns for women's issues. We've actually participated in events encouraging women to run for politics, and I appreciate her enthusiasm and keen interest to make sure that there is equality for women across this country. As some of my colleagues have pointed out this morning, Aboriginal women lack a fundamental right that the rest of the women, and in fact my colleague in this House, share today, which is if we are in a relationship that ends, we receive or have the right to receive 50% or more of the property that was part of that relationship. And this is a fundamental right. If any of us stood up in this House today to share a story where that wasn't the case, there would be shared outrage, shared concern for a lack of equality. And I'm just wondering if my colleague, who I know shares these concerns with me, why she refuses to deny or refuses Aboriginal the same right that we have standing in his House today to have rights to our property.
Well, let's
face it, the government is ignoring Aboriginals' rights to have their own ability to control these things. Essentially, I'm going to quote Ellen Gabriel, who is a member of Kanesatake, which is within my riding, and she's a former Quebec Native Women's Association president. Quote, "It is reprehensible that the government of Canada is so eager to pass legislation that seriously impacts the collective human rights of Indigenous peoples without adequate consultations which require the free, prior and informed consent of Aboriginal peoples. While it is understood that the legislation is not accompanied by commitments to adequate financial and human resources necessary to implement laws, these bills will create further financial hardships on First Nations communities. While no one will argue against the fact that solutions must be found on the issue of gender discrimination in regards to MRP, or that we must work together to find ways to help First Nations communities to have access to safe drinking water, sharing equal responsibility requires the means to effectively implement measures that do not create further burden upon communities, financial or otherwise." End quote. I just want to say the thing with this bill is that it requires more financial, actual consultation so that we can actually implement rights for Aboriginal peoples, not just...
Order. Questions and comments? The Honourable Member for London Fanshawe.
Well, thank you, Mr. Speaker, and I want to thank my colleague for her intervention and also say that as a member or former member of the Committee for the Status of Women, she does most certainly have some insights into the situation. Interestingly enough, as an MP in an area that contains a reserve, she would also be very, very aware of the fact that the resources are quite limited in terms of land mass, in terms of educational opportunities, in terms of federal investment. And I would like to ask her in regard to the fact that there has for a number of years been a 2% cap on investments or financial resources given to First Nations, despite the fact that that is an exploding population. It's the fastest population growth in Canada. And I'm interested in as an MP with a reservation in her area, her ideas and comments.
The Honourable Member for Argenteuil-Pepino-Mirabel, a shorter answer, please.
I thank my colleague for bringing that up. Actually, I'm going to go and say that actually one of the things that has recently happened at Kanesatake is that they had their NCBR funding cut. Unexpectedly. It just didn't come in. It normally comes in every year, and after attempting to find out what was going on, finally there was a letter from AND saying basically, well, we've cut this, it's over, you're not getting any. Final decision. This is extremely frustrating. It took about six, 7 months to actually get that letter, first of all, to understand what the heck was happening. NCBR funding, it went towards youth centers that children would go to after school if they didn't have anywhere else to go. And had programming. It also provided lunch programs at the schools. There's so many kids who can't afford to have lunch. They won't have a meal that day unless the school provides it for them. I mean, we're talking about serious problems, and ignoring these problems and just implementing bills unilaterally that are going to cause more financial problems is actually worse for Aboriginal rights than supposedly solving MRP. Thank you, Mr. Speaker.